Hey everyone, I'm Vladimir GT. You've been watching a CBS News special report. That special report having to do with the Supreme Court justices that just ruled on a case that could have an impact on the prosecutions of hundreds of January 6 cases, as well as the special counsel case against former President Donald Trump. The justices chose to narrow the Justice Department's use of a federal obstruction statute leveled against scores of people who breached the Capitol building on January 6. Former President Trump was also charged with 2 counts of obstruction for his alleged attempt to overturn the 2020 election results. Defense attorney and former federal prosecutor Scott Fredericksen joins me now to talk about this. So, Scott, this was really interesting. This is a post-Enron federal obstruction statute that was implemented in the wake of that Enron case. You'll remember I worked on Wall Street back at the time. Enron was a devastating money loser for many, many Americans who had invested in that company, either through their 401k or individually. That law was put into place. And here's part of what the statute says, right, which is that whoever corruptly, and there's a bunch of stuff here that has to do with alters, destroys, or mutilates, or conceals a record or document. That's not what the court was dealing with. The court wanted to focus on whoever otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. That is what they were using in this particular case that the Supreme Court was deciding. You heard the analysis on the special report. What more can you add for context?
Well, this decision goes off on a fairly narrow statutory interpretation. This court, the majority, essentially saying, well, look at the first paragraph that you just referenced talks about destruction of documents. And so when it says otherwise corruptly obstructs proceedings, that must have to do with documents and evidence. The dissent led by Amy Coney Barrett says that's not true. This is intentionally a broadly structured statute by Congress, but that did not carry the day. So here the Supreme Court is again taking a position to really carefully retract the powers of prosecutors in their interpretation of statutes. So not a surprise based on oral arguments. We probably saw this coming. A significant impact on a minority of the January 6 rioters. The vast majority of them were charged with other violations, not just this one. And for President Trump, he was charged with 2 counts under this statute. This will go back, and the special counsel, Jack Smith, can decide to drop those counts. But he also has an argument to say, look, the president conspired with others to create false slates of electors, and that satisfies this statute, even under this very restrictive reading and ruling by the majority here. So more to be heard on that when that case eventually goes back to the district court.
Scott, let me just ask you before I let you go about the way that the decision came down. In other words, we see Amy Coney Barrett with the minority writing that dissent, and we see Associate Justice Ketanji Brown Jackson siding with the other conservative members of the court. I know it's impossible to get into the minds of these Supreme Court justices, but just help people understand in the world where we live in now, where everything is binary and everything is political and we feel more divided than ever, it is interesting to see a conservative justice siding with the liberals and a liberal justice siding with the conservatives.
Very interesting. And let me speculate why Ketanji Brown Jackson, Justice Jackson, sided with the conservatives. Her background, in addition to being a judge, before that, she was a federal public defender, well-respected one. And this would be that kind of position that a defense counsel would very much take, that, look, the government's overreaching. This is a broad interpretation of the statute, and that should not be allowed. And that's, I think, why she joined with the majority here. Meanwhile, Amy Coney Barrett, who's really, I think, carving out a real separate, independent space for herself this term. And this is a good example. She says, look, the plain meaning of the statute is to be broad. Why can't we read it that way? And frankly, I think she has the better argument.
All right, Scott Fredericksen, thank you, my friend. Appreciate it.
My pleasure, Vlad.
All right, let's go back to Katrina Kaufman, who is standing outside of the Supreme Court of the United States. Katrina, you heard the discussion that I was having with Scott. You heard the discussion at the CBS News special report. Very interesting ruling here.
This is a very interesting ruling, and one thing that Scott was saying really struck me related to how this could impact special counsel Jack Smith's case against former President Donald Trump. Because this narrows the scope of the obstruction charges, it doesn't mean that it necessarily strikes them from the indictment, because there are, in particular, these actions that Trump took related to the fake electors scheme that Scott was talking about. And that really falls within the scope of how the justices are defining this obstruction statute now. So Jack Smith is really going to have to take a look back at these obstruction charges, figure out whether he can move forward with them as they are, because they are very important to his case. They allow him to tell the story of the Capitol riot that took place on January 6th, of Trump's role in it, to have witnesses from that riot at the trial as well. So it's very, very important to the narrative that he wants to convey to a jury when this case goes to trial.
All right. Katrina Kaufman standing outside of the Supreme Court of the United States. Katrina, I'll probably be talking to you on Monday. Actually, I won't, because I'll be on vacation, but you'll be there, and we'll check in with you as a network later throughout the week as we await more decisions. Thanks, Katrina. Let's bring in CBS News Chief Legal Correspondent Jan Crawford, who's also with us from Washington. So, Jan, impressions. I was really intrigued. I know we've broken down this decision, and we've broken down the earlier decisions that came down this morning, but I'm intrigued by what Scott Fredericksen was saying about what he called the path that Justice Amy Coney Barrett is carving out for herself at this term. What did you make of that, and of Associate Justice Ketanji Brown Jackson siding with the conservatives in this case?
Yeah, I mean, I agree with all of that. I mean, I think we're going to be seeing a lot of headlines at the end of the term on these think pieces where people are kind of saying, like, it's Justice Barrett's court, because she has shown a willingness to kind of go away from some of the positions that conservatives have taken and join with liberals, unusual alliances, or limit the reach of what some of the conservatives may want to do. On some of these cases, as Barrett goes, I think you're going to be able to say, so goes the court. Justice Jackson, also a fascinating figure to look. And, you know, when I think about when we talk about the court and what's the state of the court, you have to, it's like remember in the old days when we had those Polaroid pictures? You know, now I don't think we have.
I do remember
them. It takes time. You know, it takes time. You shake it, but it takes time for those images to come into focus and clarity. And that's always true when you have new justices joining the court. How does that affect the dynamics of the court? Where do the justices go? And so we're starting to see that snapshot become more clear. And you're seeing great independence from Justice Barrett and also from Justice Jackson. I think her joining with the Chief Justice's opinion today is entirely consistent with what we would expect, as Scott said, from a former public defender. You might even think, like, this should have been the liberal position. You know, liberals used to, you would say, get really concerned about prosecutorial overreach and due process and taking criminal charges beyond what perhaps Congress intended. So you could say she's kind of being true to form there. But at any rate, I think it's going to be a fascinating term. And then, of course, we've got that big immunity decision. Monday will be the last day of the term, the big immunity decision that's going to be coming down on that day. So who knows what that lineup will be.
Jan, brilliant metaphor, the idea of the Polaroid picture. And for viewers of our broadcast who are familiar with what that was, and I think they even still have Polaroids out there, the idea that, you know, you're coming into focus as a justice, as an associate justice, is really interesting to consider.
It takes time. And already, I mean, look at some of the really interesting lineups, like even yesterday in the cases, some of the interesting lineups that we've seen already. A new justice, and when a new justice comes on the court, and Justice Jackson, of course, is the most recent one appointed by President Biden, that can cause other people to rethink their alliances, rethink their positions. It can have a big impact on the court. I think we're seeing that. And, of course, with the second most new justice, Justice Barrett. Today's opinion, just to reiterate, though, and get back to that, Vlad, this is, of course, a win for some of these January 6th defendants. But as you've been discussing, this is not necessarily a win for Donald Trump. And I want to raise one thing. There is an opinion, which I have in my hot little hands, from a judge in the D.C. Circuit here, the Federal Appeals Court here. She just wrote this in a totally different case. that I think provides a real roadmap for Special Counsel Jack Smith to go forward with this obstruction charge against Trump. She talks about, like, if you can show, for example, that they're there to actually corruptly try to interfere with the looking of evidence, those state election certificates, the slate of electors, that you can still go forward with these charges. So I think he will have a strong argument that Trump, had that kind of intent to interfere with the counting of those votes, unlike some of the other people who may have just gotten caught up in the mob and found themselves in the Capitol.
Yeah, it was argued during this trial or this session of the Supreme Court, Jan, that the former president was trying to obstruct the arrival of certificates arriving to the vice president's desk for counting, which is a thing, they argued, used in an official proceeding.
That's right.
Right. All right, Jan Crawford, always great to have your brilliant analysis and reporting. Thank you very much, and for sharing that new nugget for us and our viewers. We appreciate you.
Thanks.
All right, let's go to Scott MacFarlane. Scott has been covering January 6th from that very day, and he has followed the trials of those January 6th defendants. So the question, Scott, that I have, and I have not covered this in the way that you have, and I'm not a lawyer, but does this ruling mean that there are some of those January 6 folks who went to prison who are going to get out of jail now?
Oh, it sure does, Vlad. It's a matter of how many. Of the 1,400 or so January 6 defendants, yes, there have been that many, about 250 had that top-line felony of obstruction of an official proceeding. It was one of the felonies they faced. About 30 of them face the prospect of or are serving prison time, with that being the only felony charge. So with the Supreme Court appearing to move backward on obstruction of an official proceeding, those 30 or so face the prospect of having their prison terms shortened or their prison terms ended. And that's important for several reasons, but not the least of which is that it also may limit the Department of Justice's ability to bring felonies against future defendants, because they've been unequivocal, Vlad. They say there are more people to be arrested and more people to be charged, even though we are more than 41 months since the U.S. Capitol insurrection itself. As the cases have meandered their way through the court system, we've noted a number of the highest level defendants, those names you might recognize, like the Proud Boys or the Oath Keepers, face this charge too, accused of conspiracy or of assaulting police, but also of obstructing an official proceeding. We don't expect those defendants to feel any impact. If you were charged and convicted of a different felony, you're already going to serve a pretty lengthy period of prison. And it's also unlikely, based on my latest reporting, Vlad, that some of those defendants who've already had their cases closed, faced a sentence or faced a plea deal, would try to revisit everything, facing the possibility they may have a plea deal that's less generous this time, may not result in a prison term shortening at all.
All right, you've got your work cut out for you when those prison releases happen. Scott, you've been covering the story, and we appreciate you, man, always. Thank you. All right, let's get into it with former Deputy Assistant Attorney General Tom Dupree. He joins me now to talk about this. So, Tom, you heard Scott's reporting that there is the assumption that some of these January 6 defendants will be let out of jail based on this ruling from the Supreme Court. My question is, what about the cases that are going through the courts right now?
Right. I think the case is going through the courts right now. I think the prosecutors are going to have to reevaluate whether or not the charges are appropriate in each and every case. I think what the prosecutors will need to do is to take a look at the new guidance the Supreme Court has given about the proper, limited, narrower interpretation of the statute and say, is this an appropriate charge in this particular case? I think in some cases they might say, absolutely, we've got the evidence that would support a charge under the new standard. I think in other cases they might say, well, wait a minute, maybe this is a bit of an overreach. We don't have the evidence that fits this new standard, and so we're going to drop that charge. In other cases, they might say, well, as we currently allege it, we don't have the evidence, but we do have some other evidence. We can work into the complaint, modify the challenge or the claim a little bit, and continue on that way. So I think there are a variety of roads here for the prosecutors, but the one thing they are going to have to do is look at each and every case where they brought this charge and make sure that it remains appropriate to do so.
So, Tom, let me just get your analysis of this decision. What did you make of it, and do you agree with the majority?
Sure. Let's see. On the majority, I think the majority did get it right. Look, this is not a surprising decision, particularly in light of the way the Supreme Court has interpreted these types of criminal statutes in the past. They are very interested and focused on giving these statutes a fairly narrow literal reading, particularly in the criminal context. So from that perspective, it's not a surprise. One surprising aspect of the ruling, though, was the lineup there that we've got on the screen, where you see that Justice Barrett was the leader of the dissenters, and you had Justice Ketanji Brown Jackson, who's not exactly a conservative, siding with the majority. So if nothing else, I think this decision does kind of undermine the narrative that's out there that this is a politically driven Supreme Court where people just put on their ideological blinders and vote either with the conservatives or with the liberals. You had some very, very interesting voting alignments in this case today.
All right, Tom Dupree, always great to have you, my friend. Thank you very, very much. Appreciate you.